Hi, I'm May, and I'm a junior at Georgetown University in Washington, D.C.
And I'm Sylvie, and I'm a senior at Washington University in St. Louis.
If you're also a college student, then Title IX is a law that protects your right to an education free of sexual harassment, discrimination, and assault. But what happens when the system doesn't protect you? Or worse, it silences you. The Trump administration has put Title IX in jeopardy, but your rights still matter, and you still have power. We're Interns for Equal Rights Advocates, which is a nonprofit organization founded in San Francisco in 1974. It fights for equal rights and opportunities for all genders in universities and workplaces.
We were most interested in Title IX of all the issues that ERA works with because as college students, Title IX impacts our school's policies as it does many of yours. And we've been able to learn so much from civil rights experts while working here. And we wanted to share everything we've learned about our protections and rights as students with any of our peers. And so we were lucky enough to talk to two ERA attorneys and get them to hop on the mic to talk about Title IX, what it is, its protections, and how it's being rolled back under the Trump administration.
And what we can do about it.
So let's get into it.
Flash to our duo podcast intro. We are joined by Maha, Ibrahim, and Kel O'Hara. Maha has been an attorney at ERA for 10 years. She's our managing attorney of our End Sexual Violence in Education program, and before that, she was a congressional and legislative staffer for 8 years. She graduated from Riverside Community College in 2004, Berkeley in 2006, and UCLA School of Law with a specialization in critical race theory and public interest law in 2015.
Kel is our senior staff attorney focused on policy and education equity. They started at ERA as a legal fellow 6 years ago when they created the first project in the country to focus on supporting LGBTQ plus student survivors of sexual violence under Title IX. Before moving to California to attend Berkeley Law, they were a certified crisis counselor for survivors at Bellevue Hospital in Manhattan. Thank you so much for being here.
Thanks for having us. This is very exciting.
Let's get started. Title IX is a law that was passed in 1972 as a civil rights law to protect students and educators from sex-based discrimination in federally funded schools. As a former college athlete, I knew it best as a rule that mandated gender equality for women in sports, but I've come to learn that it covers a lot more than that. Kel, can you tell us about the broader scope of what Title IX covers?
Sure. So Title IX covers all forms of sex discrimination in any of the school's programs or activities as long as that school receives federal funding. So that's going to cover everything from athletics, like you mentioned, to academics, to students' access to facilities like locker rooms and like the actual physical building, right? There's some limited exceptions, like for religious institutions, they don't necessarily have to follow every provision in Title IX, but generally it's going to apply if you get federal funds. A couple things to clarify: sex discrimination can take a lot of different forms, right? So sexual misconduct, like sexual harassment and assaults, discrimination against pregnant and parenting students, and then unequal opportunities, like in something like athletics or in academics. And when we are talking about federal funding, which is the real hook for Title IX, so what makes it apply, that really applies to any federal funding that a school receives, right? As long as they're getting some form of federal money, then that means that they have to follow Title IX. So that includes things like if you have students at a school that are receiving federal loans or federal grants to help pay for their tuition, then that creates a Title IX hook. And when we say that a school can't discriminate, that means a couple different things. That means that one, the school itself and officials for the school cannot discriminate, so you can't have things like discriminatory school policies. But it also means that schools have an obligation to respond to discriminatory conduct that maybe they themselves are not doing. So for example, we talk about sexual assault and sexual harassment. If a student harasses another student, Title IX isn't saying you can't do that, right? What Title IX is saying is that the school has an obligation to react to that, to respond, to remedy the educational environment, to protect that equal access to education.
Got it. Yeah, thank you. So one of the key aspects that you just covered very briefly of Title IX is protections against sexual violence and sexual harassment. But when it was first passed, my understanding is that it wasn't intended to protect against those things. Maha, can you tell us how Title IX developed to protect students and staff from sexual misconduct?
Yeah, so first of all, a small correction. It's not that it wasn't intended. It's that its intention is so broad that it took some decades of interpretation for us really get at the heart of what's keeping people out of an equal access to education. So the intention of Title IX has never changed. It was promulgated by Congress. It was debated on the floor. There's rich legislative history and rich social history and social movement and social activism history about how we got to Title IX and what Title IX meant to do. And foundationally, the point is this: Title IX's intent has been, was, and is now to protect equal access to education regardless of your sex, gender identity. It may not have explicitly spelled everything out. It's a very short statute. It's just some tens of words, but it's a very broad mandate. And the mandate is you shouldn't be treated differently, be treated poorly, be excluded from, or be harassed at school because of who you are based on your gender, sex, gender identity. So when we say that it developed to include sexual violence, sexual harassment, what we really mean is that as the law was in place, was being practiced, as students were voicing what it was that was really keeping them out of school or keeping them out of equal access to programs, it became very clear very early on that sexual violence and harassment was a huge problem across the country. So very early in the law's existence, in 1976, there was a famous Yale case that went all the way up to the Supreme Court. Equal rights advocates was involved as amici. That means friends of the court. You submit briefs with legal arguments and research and data to help the court make a good decision in a case. And that found explicitly that what we already know, Title IX prohibits sex discrimination, and what that case found was that sexual harassment is a form of unlawful sex discrimination. So that was the first case that really explicitly said, look, we know what the intent of Title IX was. It was to protect equal access, and you can't protect equal access if you're not protecting against sexual harassment, because that is one of the primary ways that discrimination against folks because of their sex occurs on our campuses, whether that's K-12 or higher ed. The law continued to develop throughout the 80s and 90s. In the early 90s, there was a series of cases, and often lawyers read cases in sort of units, like 5 or 6 that happen close together, and that becomes sort of a seminal moment in civil rights history to help us interpret what the original intent of the law always was. So in the early 90s, there were a series of cases that also clarified that although it is the school, as Kel said, that owes the obligation to the students to protect them from sex discrimination and harassment and sexual violence, behavior between peers, your own fellow students, can be unlawful sex discrimination and harassment if the school doesn't properly address it when they know about it. So that series of cases in the early 90s clarified it's not just if an administrator hurts you or a professor hurts you or a teacher or a coach hurts you. If your classmate, your colleague, or a janitor or a visitor, if somebody else within the school community hurts you and the school doesn't do anything about it, that's also unlawful discrimination that the school has failed to protect against.
Your work has been critical in developing how Title IX can protect student survivors. Can you tell us about your experience joining ERA and working on those issues?
Sure. I actually didn't, unlike Kel, I didn't come to ERA with a lot of Title IX experience or a long history of student activism and expertise. I came to Title IX as more of a generalist civil rights attorney that was broadly interested in gender issues and was really open to practicing any of the many areas that ERA is famous for. But what happens sometimes in the course of civil rights, and it's happening right now, and I'm sure a lot of students watching this may be feeling this in their own life, is moments arise, need arises. And while you may not have come to a place with a specific intention, the intention can develop because you see a need. So at ERA, what occurred was 2 things. One, the attorney that was in charge of Title IX went on to private practice. I was a new fellow, but it was an opportunity for me to really jump in, to what was so clearly such an important area of law. I loved the client population. I loved the bravery and the brilliance and the resilience of students. And I began to fall in love with the issue area. So it became my job. And then I kept doing it and kept developing it until it became part of what my contribution was to my period here at ERA. And then ERA, historically, we were open to all areas of Title IX. We still are. But a lot of our cases prior to those years, which was the mid-2010s, 2015, 16, 17, were sports cases. There was a lot of development in sports case law, and we had been involved in some really important cases that had defined the rights for student athletes. But what was occurring during the first Trump administration was a huge uptick in violence, predatory violence, rape, sexual harassment, sexual assault. And that was my first full year of practice here, was the first full year of the first Trump administration. And it was the first time we saw the terrifying and dramatic change that happens when it feels like permission is given from a very high level to discriminate. That signal came out loud and clear. That year, 2016, the Southern Poverty Law Center found that the highest and most rapidly increasing incidents of hate crime were against women in the LGBTQI community within the first 6 months of that administration. So the need was huge. We were getting calls from all over the country, things happening at grade schools and universities. And we saw a void in folks that were really rolling up their sleeves and able to jump into gender-based violence and harassment. And one of the things that I've always loved about ERA is we saw the need, so we just did it. And that's how I got involved in this work.
Yeah, thank you. That's amazing. And Cal has also had a huge impact on the way ERA handles these cases. Do you remember when Cal first joined ERA, and could you tell us a little bit about how they changed the way that we approach these issues?
I can't forget when Cal first joined ERA, and I almost can't forget every week Cal's been at ERA. I mean, Cal is just one of those people that arrives on the scene with a plan, but with the flexibility and the energy and the brilliance to pivot, to adjust, to absorb new information. ERA has always had LGBTQI clients since the very early days of our practice. But Kel really came here and said, there's serving people that have certain identities, and that sort of is a happenstance of your practice area. And then there's dedicating your work and your understanding and your energies to a community and to causes and to really becoming experts. And Kel brought that. And I think that's just lovely, because it also shows that movements aren't stagnant, and your youth is a benefit. You know, bringing new ideas, being student activists, having experience that is before law school or before undergrad or from a different field and changing fields. These aren't deficits. These are pluses. These are strengths. And Kel really brought that bravely. And because of that, really radically changed and improved our ability to do Title IX and really say, you know, the LGBTQI community isn't something that happens in Title IX. It needs to be a central focus.
Right, thank you. I also know that you had previously said Kel's former experience as a crisis counselor also brought this idea of trauma or trauma-informed lawyering. Can you tell us a little bit about that?
Yeah, and this is a new area really in legal practice. You know, for a long time, the practice of law, even if you're, you know, the quote unquote good folks, is just a really kind of rough and tumble, gritty experience. It was sort of survival of the fittest, duke it out. If you don't make it, the system will churn you out and a new young lawyer will come and take your place. And ERA tried to be different. When I started a couple years before Kel, I was telling my colleagues at our meetings, I said, this is such a wonderful place because lawyers take care of each other, lawyers are kind to each other, lawyers. But our principle of doing that was really just a principle of kindness. And when Cal came, they really introduced to us the idea that being kind is great, but there's actual research and practices, and there's a emerging field of trauma-informed lawyering, of trauma-informed management in law firms, of a way of revolutionizing the practice of law that's better for lawyers, way better for clients, and intentional. So that really was another thing that Cal brought that didn't only have a huge impact at equal rights advocates, but they give presentations to private and public and government lawyers all over the country. And right now, 2025 is, this is a new area in our field, and it's emerging, and it's, the few and far between experts like Cal that are bringing people into this. One of the worst calls I would get on our national advice and counseling line were from survivors who spoke to other attorneys or firms, and the experience of working with a lawyer was even more damaging to them, caused more damage and harm. And it wasn't because those lawyers were necessarily bad people. It was because they had learned to practice law in a certain kind of way. And so Kel's brought that to us, Kel's bringing it to others, and it's just another great example of the way that this field isn't stagnant and it's really developing.
Kel, could you tell us what exactly trauma-informed lawyering is and how especially it applies to Title IX law?
Yeah, sure. So trauma-informed lawyering, broadly speaking, is understanding and applying that understanding of trauma to your everyday practice as a lawyer. So that looks like a couple different things. One is understanding that the vast majority of clients that you are working with, especially in what we do, are coming into your case with some kind of trauma, right? There's both the trauma of whatever the case itself is. Like, it's pretty rare for someone to need a lawyer because something good happened, every so often. But usually if we're working with someone, it's because something bad happened, right? So there's that. And then there's also just like the traumatization of the identities we hold and the way we move through the world, right? And so, as someone who works with a lot of LGBTQ clients, a lot of clients of color, those are folks who've been traumatized by the inequities they faced in general. And so they're bringing that into the work too. So one part of it is understanding that and being able to work with it. And when I say being able to work with it, I mean understanding how it impacts your representation and being able to navigate that with your client. So one example, trauma can impact memory, right? It can make it hard to remember certain details because trauma shifts where things are stored in your brain, basically how you process things. And in the law, we really care about credibility, right? We care about things being really clear and having a super clear linear time frame. And if you are processing something through your traumatic memory, it's really hard to do that. So do you understand that that is something your client might be struggling with? Do you understand how to help them move through that and get you to where you need to go as a lawyer to get the facts on the page that you need and to be able to express that? And then if that client has to go, for example, to court or a hearing and talk about those things, do you know how to coach that client through being able to do that in a way that is going to support their case and that accounts for what they may be experiencing, right? And then the other part that Maha alluded to is that our jobs often require us to re-traumatize clients. And I don't think we like to say that as lawyers, but it is just true that when we have to ask a client to tell us every awful detail of the thing that happened to them, like that's traumatizing, right? That's really hard to do. So do you recognize that you're doing that? And are you able to work with that in the way that at least minimizes the re-traumatization as much as possible? Is that part of what you're bringing to your representation? And then I think the other part of it is understanding that as people who work with traumatized clients a lot, we are experiencing what is called vicarious or secondary trauma. And the impacts of that can look very similar to the effects of primary trauma, right? So that can ultimately lead to burnout or what is sometimes called compassion fatigue, where it's really hard for us to continue to do our work well and to do our work with empathy and compassion and care. So recognizing that that is true, being able to take care of yourself through that, knowing the warning signs so you can back off or adjust your practice to the extent that you need to. And this is all, of course, relevant to Title IX because exactly what I sort of started with, right? Like a lot of people who are coming to us as civil rights attorneys who need Title IX help have experienced some form of trauma. often in the context of their case, often in the context of their larger identity as someone who is impacted by gender marginalization. And so being able to work with how trauma impacts those clients is a really, really important part of what we do.
Yeah, thank you for that explanation. I think I'm glad that we're able to tell people about this, because I feel like the general consensus is like lawyers lack emotional intelligence and like kind of suck.
That's not unfair, to be honest.
Not an unfair characterization.
So I'm glad that this is a thing, and that obviously it's so important in cases like these. So yeah, it's great. Thank you. So a lot of people might not even know the very basics of bringing a Title IX case. So my understanding for student survivors is that they can report to their Title IX coordinator or a trusted university employee. Then the school has the legal obligation and responsibility to investigate and adjudicate the case. I can imagine these cases vary drastically based on the context, based on the university. Could you give us an example of a typical Title IX case having to do with sexual violence or misconduct that you've worked on, and maybe a challenge that you guys encountered along the process?
Sure. So there are going to be changes case to case, school to school, but generally there are certain requirements at the federal level for how these cases are supposed to go. So I'll sort of walk through what that looked like in one of my cases. So the case that I'm thinking of, this was a student who was sexually assaulted during her orientation week. So she hadn't even started college yet. She, at the time, was 17, so not of age, and was assaulted by a third-year student. And so she was in a really vulnerable position because this is a brand new place. She's away from home for the first time. It's all new friends, right? She doesn't have her like trusted support system. And actually that experience of being assaulted in the very beginning of the school year is so common that we have a name for it. It's called the red zone. There's this real spike in sexual assaults that happen between the start of the semester and around Thanksgiving. So she was really in that red zone and experienced that red zone. So it took her a while to process what had happened to her and to feel able to come forward. Again, that's very typical. Just sort of needed time to sort through things, to accept what's happened, to be able to not just be able to confront it yourself, but to be able to talk to other people about it, right? And so she got in touch with both the Title IX office to report it and also the confidential counselors on campus who provide more support around the emotional considerations and sort of like advising on options and things like that. And that's who helped her get in touch with me. So my role in a Title IX process, I do a little bit less direct representation these days, but when I was doing those cases, my role would typically be as an advisor. In a Title IX process, you are entitled to a support person, so that's kind of like your emotional support person, and then you're also entitled to an advisor who is really there to advise you on the process, right? So it doesn't have to be a lawyer. These days it often is. And so we're there to really help them understand what's going on, to help them understand how to respond to what's going on, respond to each stage of the process, because there are a lot of points where you have to do certain things, right? So once we're in the process, my client, the survivor, is called the complainant. The other party, so the person who assaulted her, is called the respondent. And both the complainant and the respondent went through interviews with the Title IX office. They had an investigator assigned that was taking care of everything. And then we're also asked to submit witness names. So folks who had either firsthand knowledge of what had happened or were, had secondhand knowledge, had been talked to about it, anything like that. And then also any documentary evidence they had. The witnesses also got interviewed. We go through that whole process. And then we go through what's called evidence review, which is where both parties have the opportunity to review all the evidence that's been submitted and respond to it. So often that's the first time that my client will see what the other side is saying, which can be pretty challenging, but at least you know what's going on, right? So you go through that part of it. And then in this particular case, and what's generally required these days, is that we then went to a hearing. And at the hearing, you kind of do it all again, which can get confusing for clients because they're like, well, didn't we already do this? It's a long story, but basically we have to do it again, and we have to do it in front of a hearing officer, a hearing panel. In this case, it was a hearing officer. And they're looking for things like, are the stories consistent from what was reported, initially, right? Like, are the facts and details the same from the initial interview to the hearing? Is there any other information that maybe didn't get dug into as much in the investigation that they think is relevant? And then they're assessing for credibility, which basically means, do they feel like the person's telling the truth, right? And so we went through all of that. And then on the other side, that hearing officer made a final determination of responsibility. So basically, is the respondent responsible for violating school policy or not? That's ultimately what we're deciding in a Title IX case, is was policy violated? In that case, and in the vast majority of cases I've worked on, the standard has been preponderance of the evidence, which means it is more likely than not that the reported incident happened. So it can be 51% likely it happened to 49% not likely, but that's still enough, right? You still get over the threshold. In this case, we did get a finding of responsibility, and then we went through sanctions. So then the school decided what the punishment would be. Often in sexual assault cases, you're looking at suspension or expulsion, and there are certain factors that are going to affect that. So in this particular case, it was considered aggravated because the harmer was making certain like conscious choices to incapacitate my client and to put them in a worse position. And so that was, this was like really intentional manipulation of the situation. So that can also look like if you're like physically threatening someone or something like that, or if you physically hurt someone, that can be aggravated. And so in that case, it was a more serious punishment. So that's sort of an overview of how the process worked. But the thing I would also say that made that, in my mind, a more typical process or an example of what can often happen in a Title IX process is sort of the human elements of what was involved, right? And so my client did not tell her parents what was going on for the vast majority of time we were working together because she was trying to protect them. She knew that they would be really upset by what happened. She didn't want them to know that, her first week at college had been like this. And she didn't want them to be, she was worried, like maybe they'll make me come home or maybe they'll, not be able to get over this. And that's not uncommon. I think I see a lot of my clients really afraid of how their parents are going to react, either because of cultural norms where there's not really an ability to talk about sex and sexual violence in an open way, or just so the emotional considerations of I'm worried my parents will be disappointed in me, or I'm worried that my parents will be sad. That's really common. Another part of that was a pretty typical experience was that we had secondary survivors involved who also were really impacted by the case. So two of the witnesses were friends of my client that had walked in sort of the middle of the assault. And they were really traumatized by what happened, right? Like it was what they walked into was really upsetting. The aftermath was really upsetting. And they had a really hard time talking about it because they felt guilty and they felt responsible and they felt really bad about what had happened to their new friend, right? And so that was also part of my work, was helping them understand sort of like how they were feeling and how that was impacting how they talked about it, because they were really understating what happened in the initial interviews because they had such a hard time talking about it. So before the hearing, we had to go through and say like, okay, why is it important to like be more explicit about what you saw, and why is it important to sort of work through some of these feelings, right? I think that was really healing, both for my client and for her friends, to be able to talk about that really directly together, right? And then I would say that the last thing that I think of as like typical, at least in an ideal world, is that my client had a really beautiful support system. And I think that that's such an important part of getting through a Title IX case. So in her case, this all happened during COVID. So that was the start of when we did Zoom hearings. Now, often these hearings are on Zoom because it's just easier for everyone, but that didn't really start until the pandemic. So we were all stuck at home. And her support person was not physically with her. He was somewhere else. So we get through this whole hearing and we get to the end and we all feel really good about what's happening. And we all went, into like a breakout room and got on camera to be like, oh my God, everyone did a good job. And this guy turns on his camera and he's sitting in a bathtub. I was like, dude, what are you doing? And he was like, oh, I'm like stuck with all my roommates and I didn't want them to hear what was going on. And the only private place I could find was the bathroom. So he did this like 8-hour hearing day, like sitting in the bathtub of his apartment. And it's like one of my favorite case memories because it was just so, this was like one of her like longtime childhood best friends. And it was just so genuine, right? And he was like, I will do anything, even sit in a bathtub for 8 hours, like to be with you, right? I'm like getting a little emotional thinking about it. And that is like how I see people show up for my clients all the time. And when I think about like, what does it mean to get through this? And like, what does it mean to think about the things in a Title IX process that are hopeful? It's that like, we really see how community shows up, right? And we really see how community gets us through. And that's what I try to really emphasize with my clients is like, how am I as your advisor, attorney showing up for you? How are your friends showing up for you? How are you showing up for yourself? And that's really what I try to bring the focus back to, because we can't change the systems, right? We can't make someone decide the case the way we want to. We can't make them understand that we deserve justice, but we can, make sure that we understand that we deserve justice, and the justice can look like healing and moving forward in ways that can be sort of unexpected and beautiful.
Wow, that was really powerful and uplifting. I don't mean to take it back to a dark place at all, and we'll get back to hope.
It's okay. This is the cycle, right?
On civil rights, you're always taking it back to a dark place.
Yeah, this is like
And then hope, hopefully.
Because we're trying to fight, we're always fighting the darkness.
It does sound like up until a certain point, Title IX protections were evolving to be more and more supportive of survivors, and now I think we have a little bit more concern, and I wanted to ask you guys how those protections are under attack by this administration and how students are being impacted directly.
Well, let me first invite you to be outraged. The last time I was a student was 2012 through 2015. That's when I was at law school. I had more and better Title IX rights than you do now. That's outrageous. That's outrageous. I had directives from the federal government that acknowledged things like trauma, that acknowledged things like the need to not talk about a survivor's past sexual history as if that even matters. I had those things in writing from my federal government. I had members of agencies tasked with educating students, speaking up and talking about violence on campus, violence against women, about equality in the LGBTQI community. One of the last directives the Department of Education issued under Obama was protection of student identity in facilities at schools like bathrooms. And it was one of the first directives, it was the first directive repealed by Secretary DeVos in the first Trump administration. And the attacks have just kept coming. And what we tried to fight back during the Biden administration, again, has been immediately attacked, suppressed. And when I say suppressed, I mean these aren't even legal actions. This isn't even sort of the trajectory of the law and changes in society. Literally deleted from websites. Things that they haven't even taken the time to challenge and change, they have simply deleted from the websites so that students can't find these things, so that you don't know these letters exist, this guidance exists, these standards exist. They haven't even been repealed yet. It's a systemic campaign of ignorance to try to force people to accept that they don't deserve rights, that they don't have rights, and to forget what the rights were, as recently as 2015, which was the last time I was a student. So I invite everybody to be outraged. And it's the outrage that's going to get us our rights back and get us our rights better. Title IX was never perfect. We were fighting, but there was a train going in a direction, and the direction was forward. What's happened since the first Trump administration was taking the train off the tracks and trying to take not just Title IX, but other important student civil rights like Title VI and Title II, and turning them on their head and having this absolutely wild, incomprehensible, upside down speech that says, these laws were created. I told you at the beginning of this interview, we all know why Title IX was created. It was a clear and broad mandate. There are historically discriminated against people, and we want that to stop. And what we hear now in the world of misinformation, lies, and doublespeak is these civil rights have done a poor job in protecting the historically advantaged person, and we will only employ them to further protect that person by attacking the very communities the laws were enacted to protect. So we see now not only the destruction of the Department of Education, the elimination of Office for Civil Rights, which were the local agency branches tasked with enforcing Title IX on behalf of students, but we also see affirmative investigations being launched by this administration to attack and hunt down students at their schools and schools trying to protect their students using the laws that were created to protect the students. So I invite everybody to be outraged because it's ridiculous that at 41 years old, I have more rights I had more rights than people that are my colleagues at work. You guys are my colleagues. We come to ERA every day. I see you every day at work. We're not from different epochs. We're not from different civilizations in the history of mankind. I was a student in 2015, I'm 41, and I have experienced more gender equity protections than you have now. So, that's what we're facing. There's complexities about the legal arguments and the what litigation there is, but the one thing I can say is this: there is not a lawyer out there, there's not a Maha or a Kel that's going to bring some glorious case that's going to reinstate all these rights. What's going to get our rights back and get them back better are the students. It's going to be student activism, student demands, student insistence. That's what created Title IX in the first place. That's what's going to save Title IX, and that's what's going to get us even better laws, broader interpretations of Title IX, deeper understandings and application of Title IX, and better state and local and school level rules and laws that are even more advanced and more sophisticated and more nuanced and more intersectional and more practical. And that doesn't stop. We don't need anybody's permission to be outraged. Civil rights are not a gift given to us by the people in power. They have always been something demanded by the people who hold the rights. And that's how we're going to get them back, and that's the only way to keep the ones we have. And at the state and local level, even at the school level, what's most required now is to know what you've lost, know what you have, and have an idea of what you want to demand, and go do it. Do it. They don't need permission to make better misconduct policies, to make affirmative campus climate actions and activities to try to fight the prevalence of gender-based violence and assault on campus before it even begins, during the red zone, ahead of the red zone, upon your admission, to get the information out, to let you, this isn't a mother may I moment. You should be mad. Gender justice was never supposed to be a thing where we look at the generations older than us and go, gee, I wish I had it as good as they did.
I know that we're talking about really serious things, but I just have to say that I love it when Maha gets fired up.
I know,
It's the
I'm
best.
loving it.
So there's obviously been attacks by the Trump administration, a million, against Title IX. What has ERA been doing about these?
Well, since the first Trump administration, we have, been awake and on our feet. So during the first Trump administration, we immediately challenged some of the attacks by the DeVos Education Department. We sued federally. We had a few cases. In one of them, we prevailed in getting one of the terrible changes they tried to institute repealed. That was called the evidentiary suppression rule. And it was a rule in the regulations that they tried to promulgate at that time that would say that a student could not introduce any evidence if the source of the evidence wouldn't avail themselves to the on-campus process. This was patently ludicrous. If you get a rape kit done and the nurse that performs the rape kit won't take the day off work and come to your school to participate in a hearing and be cross-examined by your harmer, the school might reject the evidence of the rape kit. That's wild. If you file an investigative report or you texted somebody off campus, or you called your mother in Ohio, if they won't come and be directly subjected to live oral cross-examination, that evidence can't be submitted. That's wild. One of the most damaging things this administration has done is they've tried to turn schools into courts, and they've tried to turn the Title IX on-campus process into a criminal law process. This can be confusing at first blush, but it's fundamentally not confusing if you understand these foundational pillars. Civil rights and criminal law are two different things. Why? Because in criminal law, it is the state. That can be the district attorney, that can be the attorney general. It is the power of the government trying to take from an individual their freedom. We call that in the law a liberty interest. If you're found guilty of a crime, you can lose your freedom because America has a very harrowing carceral system. A civil right is not about one individual, one regular citizen trying to take the freedom of another person. It's about one individual, one regular person trying to get back or safeguard their safety and autonomy and ability to function in our society without interruption or discrimination based on who they are, right? So they've intentionally confused these things so that people can start to doubt, well, maybe schools shouldn't be looking into this because it's a crime. Maybe it should be for police departments. Maybe it should be for courts. Maybe schools should be like courts. Maybe it should be you have to prove beyond a reasonable doubt what happened to you. Schools are not courts because schools do not have the power of courts. One of the reasons we challenge this evidentiary suppression rule is because schools can't subpoena people. Courts can. Courts can force people to show up to testify. Schools can't. It's a misconduct proceeding. So to say that you couldn't admit evidence unless a person that's not a member of the school community subjects themselves to your school's misconduct proceeding is wild. Second, a student going through Title IX process is not seeking to take away the liberty, the freedom of the person that harmed them. They're seeking to restore their own access to their own education. Yes, that can mean severe misconduct consequences like being expelled, but so can plagiarism and theft. If somebody stole your laptop or copied your final exam essay, we wouldn't, sit there and say we need to have a full court hearing because, oh my God, they could be expelled. We'd go, that's a serious infraction. We should look into it under the misconduct policy. But by intentionally confusing sexual assault and harassment with the crime of sexual assault and harassment, it's to try to make it so that you're at more risk of being expelled for plagiarizing than for raping. Going to school is a social contract. You entered that contract and you agreed to abide by certain conduct policies. Some of those conduct policies are mandated by civil rights laws to help prevent discrimination based on characteristics like sex, gender identity, race, national identity, religion, etc. If you violate those misconduct policies, you can be subject to misconduct consequences, up to and including expulsion, and many other things in between. The victim is not seeking, if they're seeking a criminal outcome, they can appeal to the criminal system. But many times victims are not seeking a criminal process at all. In fact, they want to avoid a criminal process. In the 9.5 years I've been taking advice and counseling calls, I have maybe once spoken to a survivor that called us whose goal was some kind of criminal prosecution. When you get to the end of the call as a lawyer, you have to say openly without any hinting or, you don't want to shape at all what they answer. You just say openly, and why did you call us today? What is your goal in talking to a lawyer? Almost every person I've spoken to in those 9.5 years, the answer was because I don't want this to happen to anybody else and because I want to finish my education. They're not seeking a criminal outcome when they're engaging in a Title IX process. They're seeking the kinds of access and protections that only their school can give them. So it's not a court. So one of the damaging things, to answer your question, is the legalization of this process. Cal and I advocate for students, and Cal's represented a lot of students on campus, and we wish we weren't necessary. We don't think lawyers should have to be there. And the reason we've had to be there is because of this overcomplication, this over-legalization, this treating sexual assault and sexual violence as though it deserves more scrutiny and more doubt on the reporting student than things another student, than if you came and said, my roommate punched me in the face, right? The assumption isn't that you're lying and you've made this all up. So we hate that we have to do this job. And we hate that this administration is even further now trying to make this such a a harrowing experience where the beginning assumption is that they're lying. Those are the challenges that's sort of the perception of this administration. It's what they're trying to sort of confuse students on, make students doubt whether they should have these rights, whether it's appropriate for schools to even look into these things. And you just ask yourself, have there been times where you've, in any case, where you've wanted a just outcome for something, even if it unrelated to sexual assault and violence, just something happened that was bad, that you would like a remedy, but you're not trying to incarcerate the person that did it? And that's your answer. That's the difference between civil rights and criminal law.
Yeah, thank you.
And to students who are scared right now under this administration to exercise their Title IX rights, what would you say to them?
Not to be flippant, but good luck.
Yeah.
No, I mean, it's hard. I don't want to lie to anyone, right? Like, I don't want to sit here and say, like, no, like Title IX isn't a great place right now, because it's not. Like, it's not. What I would say is a couple things. One, struggles of resistance have a long and strong history, right? Fighting back against injustice is not unique to this moment. It is something that we've had to do for a very long time. So I think tapping into those histories and to that strength is something that I really try to do, and I try to encourage others to do. Two would be, whether you are someone who is impacted by these injustices yourselves, or you care about someone who is, make sure you're really paying attention and doing your best to actually understand what's going on, right? So a lot of mainstream media these days covers things in ways that are pretty inflammatory and are like meant to be scary, right? And sometimes it's not as bad as it sounds. Sometimes it is, but one example is in the LGBTQ space, there are a lot of executive orders flying around. Executive orders are not law. And so if you read that executive order and you say, oh my God, like now all of my civil rights are gone, they can't do that in an executive order. So look to organizations doing Title IX work, or whatever the area is, look to them to look for their guidance, to understand, like, what does this actually mean for me, right? And then the other thing I would say is, at moments where we can't trust the federal government, that doesn't mean that we can't trust more local resources, right? So a lot of states have like equivalent Title IX protections in their state education codes. So are the things that you're looking to do covered by your state laws? Or even if it's not in state law, is it in your school district policy? Or do you have allies within the school, even if it's just like one really good Title IX coordinator, or like one really good teacher who can have your back, whatever it is. I think community is really important, looking for allies where you can, making sure that you have a strong crew around you. Those are all the things that I think about in these moments where the protections that we wish were there are not there, because part of what we're doing is trying to stay in the fight, right? And so maybe you can't avail yourself of all the Title IX protections that you wish you could right now, but finding ways to not give up on the hope that we will have them back, and to keep resisting against the inadequate system that we have, I think is kind of sometimes the most we can do, but that is enough in these moments.
Okay, so we're going to be switching the topic a little bit, but we wanted to talk about another huge aspect of Title IX protections, and one that is heavily under attack under the Trump administration. Title IX protects students and employees of all genders from discrimination, and this has developed over time to more clearly protect LGBTQ plus individuals. Kel, can you tell us a bit about how LGBTQ plus people came to be included in Title IX protections?
Yeah, so according to many advocates, including us here at ERA, Title IX has always protected LGBTQ people, right? And that's because you cannot discriminate against someone because of their sexual orientation or because of their gender identity without discriminating on the basis of sex, right? And I can't take credit for that precise statement. That is the reasoning of the Supreme Court in a 2020 Supreme Court case called Bostock v. Clayton County. And that was about whether discrimination against LGBTQ folks is covered by Title VII, which is our kind of the equivalent of Title IX in employment law. But when we don't have something fully settled in Title IX, we often borrow from Title VII. And so right after that case came out, the Biden administration said that, we're applying that to Title IX, right? And even before that Supreme Court case, we were like, this is straightforward. But that wasn't the first time that we'd sort of explored, or administrations, I should say, had explored explicitly protecting LGBTQ students. So for example, in 2016, the Obama administration came out with guidance explicitly extending Title IX protections to transgender students, or recognizing that those protections were extended to transgender students. And so, according to us, if a student is being discriminated against because of their sexual orientation or gender identity, or their perceived sexual orientation or gender identity, then that is prohibited, right? So whether that is discrimination by teachers, harassment by peers, or there are policies within the school that are leading to unequal access. So things like trans students not being able to use the locker room that corresponds with their gender identity. All of that, we would argue, is prohibited by Title IX and has been from the beginning.
Sweet. Well, you personally have played a huge role in working on Title IX issues for LGBTQ plus students at ERA specifically. So can you talk a little bit about our organization's work for that?
Yeah, sure. So since I've been here, it's looked a couple different ways. My work, so during my time at ERA, I've moved from being like a direct service attorney, so working one-on-one with clients, to doing more policy work. So I think that was really, our LGBTQ work has sort of followed that track, right? So over time, ERA's work in support of LGBTQ students has included working on amicus briefs, like Maha explained earlier, where we are explaining to the court in more detail why they should care about certain things or what they should understand about certain things. On the policy side, when I first started tiptoeing into the policy realm, I was working some with school districts on what their school policies looked like. And so I helped a couple school districts with their trans and gender nonconforming policies, not just like what are the things that need to be covered in there, but what are the practical implications of it. So an example I often use is like, if you want to have gender inclusive bathrooms or locker rooms, and the policy says that, but the actual school building is set up so that any student who wants to use that facility has to like trek to the other side of the basement, or like the other side of the building and then down to the basement, and they're going to be late to their next class, you haven't actually guaranteed like equal access, right? And so looking at those sort of thing. Since then, I've moved, and my current role is largely focused on state policy work. And so that the LGBTQ education protections have looked at a couple different ways in there. Recently, last year, we worked on a bill called SB 1137, and that was a bill that explicitly recognized intersectionality in our anti-discrimination laws, including in our education code. And so like what that actually looks like for me as a lawyer is like, I sat down with the education code and reviewed it and said like, okay, I think this language should go here, right? And for anyone who doesn't know, intersectionality is recognizing that discrimination that happens on the basis of multiple, as we call it in the law, multiple protected classes, multiple sites of marginalization, is sort of a distinct form of discrimination from discrimination on any one of those things, right? So if you are a Black queer person, that discrimination is going to function a little bit differently because of that intersection than if you are just being discriminated against on the basis of your race, or just being discriminated against on the basis of your sexual orientation. So that's one example. Another bill that we supported but didn't actually work on, but I think is important, so I want to highlight from last year, is the Safety Act. Our friends at Equality California were a big driving force behind that one, and that made us the first state in the country to explicitly prohibit schools from establishing forced outing policies. So something that we've seen a rise of recently that is really troubling is schools implementing policies that require teachers and administrators to out students that they think are queer or trans, or know are queer or trans, whether or not that student has consented, right? And for a lot of queer and trans students, that's a really big safety issue. Like there's a reason that they're not out at home, or even if there's not a safety issue, just like the fact that that choice is taken away from them, right? And maybe they're not ready to come out to their family. So they're really problematic for a lot of reasons. So the Safety Act prohibits schools from implementing those policies and also protects teachers and educators from being forced to forcibly out students, regardless of what the policy says. And that is, unsurprisingly, a controversial bill in this day and age. So the Department of Education under the current administration has announced that they are investigating California because of this law. They're threatening to pull educational funding for the state. We'll see how it goes, right? Looking ahead, what this can look like. So when we started the last legislative session, we didn't know exactly what was going to happen in this administration. The legislative cycle starts at the very beginning of the year, so a lot of like the bills that we've been working on were sort of already in progress by the time we saw everything that was happening and has been happening over the past couple months. So next session is going to look like a lot of dealing with that. So this year we saw a handful of bills that are about protecting trans healthcare providers and the private medical information of trans folks, so that can't be used against them from out of state or at the federal level. So California is a sanctuary state. It means that we are really seeking to protect folks who come here for LGBTQ related care or support, even if they would maybe be investigated elsewhere. And so how do we protect folks in state from being investigated for those things or having their private information released? And so we're doing that in the healthcare space. Are there ways we can do that in the education space, right? Like how do we protect educators who are trying to do the right thing? How do we protect students? Another thing we've sort of been exploring or thinking about is what does it mean to more explicitly protect LGBTQ students from certain things in state? So the forced outing bill I just described is related to the actions of educators in the school, but how do we make it clear that forced outing by a peer, for example, is an actionable form of discrimination that schools are required to respond to? So yeah, like really thinking in those areas and looking in those areas and just figuring out what is everything we can do in state right now to make sure that LGBTQ students are as protected as possible here in California.
Thank you. That's great. And I know California is one of the states who works the most on this issue. But looking at like a more national scale, of course, this is a really hot topic right now. How are LGBTQ plus students' rights under attack federally right now?
The Trump administration has been coming for trans people since day one. Like literally one of the day one executive orders was instructing all federal agencies to only recognize sex assigned at birth as like immutable categories, right? Which is not how we have handled gender identity for a while, right? And a lot of that was, has shifted over the past couple administrations, and now, like literally, it was their first priority, which says a lot. And that executive order explicitly mentions Title IX as like one area where we need to really go through and make sure that we're like reinforcing these like sex assigned at birth categories. More largely what is going on is an attempt both to erase transgender folks from everyday life and to scapegoat the trans community to promote both an anti-trans agenda, but I would argue also an anti-civil rights agenda. And a lot of these things are being done supposedly in the name of cisgender women and girls, right? Like a lot of what we see is framed around like protecting girls and protecting women. So there's another executive order that is specifically about prohibiting trans women and girls from playing on women and girls sports teams, including in the education arena. And that they call like the Protecting Women and Girls Sports Act. And this is ridiculous because this is an administration who is saying that and then turning around and trying to dismantle DEI and trying to dismantle all these institutions in the federal government and rules from the federal government that are meant to protect and uplift women, right? And so it is so clearly not just about that. And they found a really easy target with trans people. And it's really working because the conversation has become so much about trans rights and what trans folks should be allowed to do and not to do. And when you really step back and think about it, there are not that many trans people in the US, right? Like young people are more likely than anyone, like anyone age-wise to identify as transgender. And like the most recent estimates I've seen, and there's going to be variation, right? But like some of the most recent estimates I've seen are that about 1.5% of like adolescents, right, like teenagers, 13 to 17, identify as trans. And in terms of trans sports, which has been like a particularly effective battleground, one, I will point out that a lot of these bills are not about removing all trans people from school sports. They're like specifically targeting trans women and girls. And so we're not talking about trans boys and men in the same way. And that's because there's this underlying narrative that like, if you are your sex assigned at birth, right, then like those are basically still girls. So like, ew, gross. But as far as trans women and girls are concerned, we're really spinning it to be a safety issue. We're making it about how trans women and girls are unsafe. They're unsafe on the field, they're unsafe in the locker room, they're predatory, they're all these things. And so these arguments are being put forward. We're spending all this time thinking about it. The trans sports bills that we're seeing really spiked in 2020. I'm not sure people realize this. You can go Google this. The number of anti-LGBTQ bills and specifically anti-trans bills have like exponentially increased since 2020. And the trans sports bills are one of the ones that like really took off. And some of the states that have passed, I want to say it's 26 states at this point have passed trans sports bans. And some of these states that have passed these sports bans, in the hearings about that legislation, they were like, okay, so like how many trans athletes are participating in school sports? And the legislators couldn't name a single trans athlete in the entire state. They were like, I don't know, this isn't actually a problem, right? But it doesn't matter. At the college level, there was a hearing in front of Congress in December where the president of the NCAA was testifying, and he said that out of 500,000, roughly 500,000 college athletes, he is aware of under 10 that are transgender. But we're spending this much time talking about it, like we're spending this much effort on it, and that's why for me, I look at it and I'm like, it's not just about attacking this one population, right? It's about what attacking that population allows us to do. And so, what are the ways that we are reinforcing gender norms and gender stereotypes by going after trans folks, right? Like transgender folks and gender nonconforming folks are a threat to the gender systems of power that exist because we prove that it doesn't have to be that way. And when you take that away, then the patriarchy as it operates within our society starts to crumble, and we can't have that, right? And so that can't be allowed to stand. But also, it's not a new strategy for systems of power to find the population that they can target most effectively and to dismantle civil rights and protections for marginalized groups more broadly by going after that, right? So this is why we talk a lot about why reproductive justice and trans justice are very related, because we're often talking about the autonomy to make your own private medical decisions, the autonomy to make private decisions in the sanctity of your own home or with your own doctor about your own body, about how you yourself want to move through the world. And we can't separate these things entirely. And that's why, we have seen over the past couple of years, in particular, the women's rights movement and the LGBTQ movement really pitted against each other. And I am always telling folks that we absolutely cannot afford to do that, right? Like, all of us who are experiencing systems of oppression, one, need to remember to reach a hand out to pull up. Like, I am a non-binary person, but I'm a non-binary person who is perceived as a white woman and a white woman lawyer and someone who has a lot of privilege, right? And for me to sit here and say I have it as bad as a Black trans woman is just not true. So can we hold that nuance within feminism? Can we hold that nuance within the work that we're trying to do? And can we make sure that we are, as we sometimes say, lifting from the bottom, right? Are we making sure that we're not leaving anyone behind? And that's something that I think a lot about, and that I think is particularly important in this moment where we are seeing this all-out attack on this one very small population.
So what would you tell an LGBTQ student who is worried about their rights right now?
I would tell them that they have every right to be scared. And I would also tell them that I hope they can find ways to not let fear win. And that's a lot easier said than done. But I look to a couple things when I say that. One is that we are fighting back against these attacks, and it's working. So one example is that the Trump administration tried to stop trans folks from getting passports that aligned with their gender identity. And we fought that one, and currently we won. It's not final. There's still more fight to be had. But currently, if you are a trans person, you can now get a passport that aligns with your gender identity. And I have personally have friends who were afraid to renew their passport or couldn't renew their passport. And now they can. So they're in this window where it's that really matters for a lot of people, right? Even no matter what happens after the final hearing, the fact that we have that preliminary injunction, so this initial decision from a judge saying you can't do this until we totally figure this out, that really matters right now. And we're doing this in educational spaces too. So remember that there are people who are out here going all out. And also some of those fights won't work, right? Won't work right now. I said this about Title IX more generally, but I think it bears repeating, which is make sure that you are paying attention to what is actually happening and learning about what's actually happening, and not getting distracted by sort of like the fear-mongery headlines. And make sure that you know what is happening in your state and at the local level. So make sure that you know, maybe this is like, do you have anything around you that you can rely on? Whether that is like an actual policy or an actual state law, or if it's just the people that have your back. And sometimes that can look sort of, I don't want to say silly, but can like happen on really different scales. I am part of a drag group called Legalized Drag, and we use a fundraising model where we went and found grassroots organizations in states that were dealing with a lot of like anti-trans, anti-drag legislation. And we did big fundraisers for them that were drag shows. And we did that here in San Francisco, where there are a lot of queer people and a lot of trans people, a lot of people who like have a lot of money because, of tech and all that. And we're lawyers. And so we have other, like, I work for a nonprofit. A lot of my friends work for big law firms where they make bank, right? And so we were like, hello, everyone, like, please come to our show and give us all of your money for these people in other states. Our first one was a fundraiser for Tennessee, because that's where one of the first drag bans happened. And I happened to go to Tennessee shortly after that show, and I went to a drag bar crawl, and I was talking to people, and I was like, yeah, I just did this show actually. And they were so stoked. And like, now we still follow each other on Instagram. And if I'm back over there, we would hang out, and like, we've like built this like cute, cool community, right? And so I think there's a lot of power in coalition building and support, like outside of your immediate bubble too. So it's not just like, do I know who my immediate community is, but it's like, do I know who's paying attention? Am I plugging in ways that allow people outside of my immediate bubble to pay attention? Like, I wouldn't always necessarily know what's happening on the ground in Tennessee, right? Because I don't live in Tennessee. But I have those connections now. Like, I have ways to try to plug in. And I have a lot of friends from the South, and friends of friends who are increasingly like leaving the South. And we are like pulling on those support networks for them too. Like, if someone feels like they need to get out to be safe, like, do they have a safe place to land? Do they have a community when they land in that place? Like, do they have the resources they need to make that? And not everyone will have those same opportunities, which breaks my heart. Like, I wish that like I could give every trans person in their family enough money to get out of a place if they were unsafe. But can we do what we can in the opportunities that we have? And are we not afraid to ask for help? I think that mutual aid is a really powerful concept. Not charity, but solidarity, right? And making sure that we have each other's backs. And that is something that queer and trans people have been doing forever. And so leaning into that, like, if I can't trust the federal government, and I can't trust the courts, and I can't trust maybe even my state, like, all we have is each other. And so that's what I would tell people to look at.
So we've established the importance of Title IX and how it has expanded to cover many different protections for university students and employees, including gender-based discrimination against students in all aspects of universities, most commonly academics, athletics, and sexual misconduct. And we also know that the Trump administration is targeting these protections through various federal actions.
Now, as a student myself, probably Sylvie too, I find myself feeling hopeless a lot of the time, but wanted to ask you, experts, is there anything I can do to help save Title IX?
Great question. I said this a little bit earlier, but I think for me, a big thing is, remembering where you are in a history and tradition of resistance. So this is a moment where there isn't necessarily a clear roadmap, right? But those moments can be really scary. They can also be very exciting and powerful. So what are the ways that you can find to not give up, right? What are the ways you can find to tap in, to feel empowered in a world that doesn't want you to feel empowered? And what are the ways that you can push back in small and big ways, in the ways that you're able to, in the ways that you're comfortable with? Another that we sort of alluded to earlier is looking at what local solutions are, right? So can you push your school district to improve their policies? Can you have your friends' backs when they're trying to deal with a sexual misconduct issue? There is, just because federal law says that it's not requiring something does not mean it is prohibited, right? Like, we can often go above what federal law is telling us. And so really pushing our own communities at the state or local level to do that, I think is a really important thing, making sure that when we can't count on what's happening nationally, making sure we can count on our own state or community.
In the early 2000s, when I was working for Congresswoman Barbara Lee, we were doing a lot of work in the Bay Area to oppose the war in Afghanistan and the war in Iraq. And at the time, she was the only member of Congress that didn't approve a blank check to the Bush administration for an endless war in Afghanistan. She was the lone vote. And we had a thing we'd say among the staff back then. I don't know if it picked up critical mass in the movement, but we would say it among the staff because, like anybody, we were like a small staff, and you can feel small. You know, you can be at your school or in your student group or in your friend group, these important different networks of support, you and one really good, safe teacher. It can feel small. But we would say to each other when we're making decisions sort of on a daily basis about what we should be doing and where we should be deploying ourselves, put your body where it's useful. We would just, if we were getting over analytical, if we were getting a little too gloomy, a little too hopeless, we would just say, just kind of shake it off and say, put your body where it's useful. Where is my body useful today? So look, if you're the student organizer or activist and you're going to organize the folks, great. I would say to you, don't reinvent the wheel. Find places like us, cold call places, cold email people. Say, you know, I saw you in this podcast. I read you did this thing and I have questions. I have questions. It's, you know, as students, you're so used to taking it upon yourselves to like do the studying and learn the thing. This is not a time to learn the thing by yourself. This is the time to pick up, my generation say pick up the phone, but send the email. You know, if you see an organization, don't go, oh my gosh, I'm just an undergrad. I can't reach out to this national organization, that lawyer, that activist. Send an email. Find the resource. So if you are the organizer, you're that kind of a student, you want to lead a thing, don't try to start all over. They like it when we start all over. They love exhausting us on starting all over. That's part of why they're deleting everything on the websites, so that we have to sort of imagine that it's never been written before and it's new. Your task is, because you're brilliant, because you're the ones living in the moment, you have the lived experiences of a student today, right now, is to not waste your time figuring out what was already done, but finding it quickly and then figuring out the next, where we need to go. Spend your energy on that, right? The inventive, creative, fierce part. And let people like us help. Grab us, pull us, you know, make us email you things, pull it from our websites. We have like a student toolkit on the ERA website. We have links to articles, we have links to cases. You can find us. If you're not that person, put your body where it's useful. If you hear that a student is trying to speak up on something in your school, if you hear that somebody's going to say something tonight at a board meeting, if you hear that they're thinking about changing this policy or that policy around gender equity, show up. Show up even if you have no idea what you're going to say or if you're going to talk. Just be a body in the room. Let them know they're being watched. Let them know you're noticing and it matters. And they can't do these things quietly or behind closed doors or without your input. Even if you don't plan on speaking, just put your body where it's useful. You may find once you get there that you find your community. You find additional people that you connect with, that you work with, and that may lead you to find a voice and you figure out a lot of things to say, or you'll always be just one of those strong pillars that's sitting in the room, the reliable face. And that's not just reliable to your fellow students, but it's reliable to the people that we need to hold accountable. These faces are watching you. These students know what you're doing in the board meetings. They know when you're arbitrarily and prematurely capitulating, when something's not really a law, when law hasn't really changed, when you're just being cowards. And your presence can make it harder for them to be cowards. And so I think those are some of the things you can do at any level right now, at a state level, at a local level, at a district level.
Someone will need to site check this number before you include it, but I'm pretty sure it's that research shows that you need 3% of a population to resist in order to have an effective resistance movement. And so that's a lot of people in the US. We have a lot of people, but in some ways it's not, right? Like 3% isn't actually that much. And so like, don't doubt that it matters, right? And the folks who have been in this movement, a lot of us stay in this movement. So when I was a student organizer in Title IX in college, like some of my heroes were students who had formed like a Title IX student advocacy group. Those are now my colleagues. Like we're on emails together all the time, which I still a little bit fangirl sometimes. But like we've all been around the block, right? Like we know what happened years ago. We know what's happening now. And then we have the folks who came up before us. Like tapping into that, like Maha was saying, is really important, because if we just are doing the same things over and over again without understanding the history, history is bound to repeat itself in good and bad ways. Make sure that you know what works, what didn't. And if what feels accessible for you is sort of like the small everyday actions, here at ERA, we have our action team. You can get emails about, when are there opportunities to send emails or write letters or whatever it is. It's a way to just like keep up with what's going on. So yeah, find those opportunities, whatever scale of action you feel you can take one step towards that. I really think that people sometimes feel like they need to do everything at once and do the biggest thing ever, but like those small steps really do matter.
I'll give a recent example. One of the sneaky, tricky ways they tried to eviscerate some more Title IX protections was to try to pass some really harmful regulations, but instead of doing it through the Department of Education, do it through the Department of Energy. We caught that because that's our job. But our comms team put it on our website, so it taught you about the issue. You could click, you could send it off. It took less than 5 minutes. But we just found out a few weeks ago, there was such a critical mass of those kind of letters that it forced them to delay the release of those harmful regulations at least until September, which gives us more time to fight. So it's those kind of things you can just sort of check. What are the sort of few things you can do each day or each week? And then you might have just your small amount of bigger things, but not everything has to be the biggest thing, like Kel said.
Yeah, thank you guys. We will put the link to the action team and newsletter in the bio, of course. And thank you guys so much for sitting with us. We learned so much as students. We learned so much about our protections, and I think we both are motivated to do some shit about it. So thank you guys so much.
Thank you guys.
Thank you. Okay. We didn't swear.
Oh, sorry. That was the biggest achievement.
I'm glad you did, but we did.
Should we do an outro?
Peace, peace, and love.
Peace, love, and power.
Don't do that again.